All right, I'd like to bring up our last speaker tonight, and that is Stephanie Gibbs. Stephanie is one of the excellent staff attorneys. She's a managing attorney of our Long Island team. She has a deep experience background in asylum law, immigration practice, litigation in immigration, but also now in about 6 or 7 different family courts throughout, maybe more. Have we counted?
At least 13 counties.
Oh, at least 13 counties in New York State. So just to give you context, because she's going to set it up, but this program really has been trying to focus on some advanced or intermediate level issues of understanding family court practice and best practice. But a lot of what we're doing in this particular program is aiming toward having the protection the child receives in family court be part of a remedy that later could be pursued before the Immigration Service. And as Judge Martino said right before he left, they seem to be changing it every day. And so Stephanie is going to give us some anticipation and understanding of what that second stage of a special immigrant juvenile case is.
Yes, thank you, Lenny. So yes, as she said, I am the supervising attorney of the Long Island team for Safe Passage Project. It's been an interesting journey. I actually, when Judge Martino was speaking earlier and he was talking about the publication that was put out by the, and now I'm completely blanking. Yes, the advisory opinion that was put out. I don't know about the rest of the practitioners who practice in Suffolk County, but there has been a marked improvement in working with the judges in Suffolk County. It's just like, I didn't think that we were gonna see it. So it's not the horror that it used to be. I mean, there's still some tough judges and there's still some tough procedural hurdles, but like it's absolutely doable. And if you wanna take a case with us, I'm happy to mentor you. But this part of and the reason we're doing a PowerPoint and the other people didn't, this part of the presentation, really, we're gonna look at the new form, which is 19 pages long. It's the December edition. And a lot of the best practices in doing that form, completing it, and then talking about the adjudication issues that we're seeing now since things have been centralized at the Missouri Service Center. The RFEs, the NYLS, the revocations. Before we jump in though, I'm just curious, how many people in this room have filed a 360 petition? How many people have gotten through that point? Okay, awesome. How many of you have filed the new form, the 19-pager? Okay, great. And how many of you have ever responded or even know what I'm talking about when I say RFE, NOID, or revocations? Okay, great. So not total novices in this room, great. But stop me, please, if I'm using any language that you don't understand or if I seem to have glossed over some concept that you want more information on. So always, always, always go to uscis.gov and make sure that you're using the most recent version and that the version that you have is still being accepted. Sometimes there is an overlap period. It seems like they're constantly updating these forms. So just always double check. And this is the form that we're using, the form I'm gonna be running through tonight is the most recent form. So we're gonna go through the form itself, best practices for how you complete it, because again, this is a national form that we are trying to make fit a state court practice, and so it's not always a one-to-one. The supporting documentation, the procedure, just keep in mind that we've created and work with this sample fitting 99% of our clients, which are UACs coming from Guatemala, El Salvador, Honduras. And so there are going to be certain areas that I'm going to flag for you that you may just want to double check. This may not apply to your client. If your client entered on a tourist visa or a student visa, there might be other additional considerations you want to look at. If your client is or isn't in removal proceedings, that might influence how you're completing certain sections of the form. So we will indicate that. And I think we've done a pretty good job of making it as clear as we could possibly. So with that said, so this is page 1. Again, as an attorney, make sure you're always completing this section. The rest of this, and I get this question all the time, you do not have to fill out page 1. In fact, you're not supposed to fill out page 1. Keep it blank, skip it, yes.
USCIS has been rejecting these for not filling out this part.
We haven't seen that. And in fact, their own instructions say,
Yes,
skip item 1 and go to,
I'm with you.
yeah.
But if this happens to you, you can email the lockbox. There's someone
That's
named
true.
Marsha, who I love, who actually really cares about these cases. So if yours gets rejected, like to find it, sometimes they just want you to fill in. It doesn't make any sense, but she'll actually call you and walk you through what she wants to do. So just as a variation, if you get that, don't get too frustrated.
Sure.
It's doable.
Yeah.
And this is a technical issue. If you don't fill in the first line, then it won't carry over to the, what do you call it, the last page that has the additional information. So you need to put in that first line to carry it over.
Oh, you mean this line with the A numbers?
The name and the A number, right? If you don't do that, then it won't carry it over.
Sure. I mean, you can always write it in by hand, which is what we've instructed people to do, but
So, just gonna stop for a minute. Can we let Stephanie get through this part, maybe keeping notes on changes, because we'd really like to have a recording of this.
sure.
And so I think the last thing that was just said, just to repeat it, is some of this fillable form software, there are some lines you need to fill.
Yes.
Okay, and now I'm gonna let you keep going.
Yeah.
So just hold your comments till she finishes this section.
We've also seen issues, just FYI, especially this summer, because we're dealing with a whole gaggle of summer interns with various software updates and whatnot. Sometimes there are issues of going Mac to PC and these forms being fillable. What you download directly from USCIS should be a fillable form, but sometimes you do run into issues and you do have to mark certain things by hand. So in any event. Continuing on, if your client needs a safe mailing address, you can complete this section here. Otherwise, this section can also be blank. This is the first part that you absolutely have to do, checking off special immigrant juvenile. And then most of the client's information, the petitioner, your client, the subject child from family court, is now the petitioner to USCIS. They are the ones that are filing their own I-360, requesting the government to consent to their designation as a special immigrant juvenile. So just keep that in your mind. Subject child equals the petitioner on this form. And this is where that information goes for that child. Other information you have to have, the date of birth, country of birth. If they have a social security number, you should include it here. A lot of the clients probably don't have that. You can leave it blank. If they have an A number, for instance, if your child was picked up at the border, processed by ORR, and currently in removal proceedings, they're gonna have a 9-digit A number. You need to put it here. Obviously, you have to mark single. If you're marking something else, you should probably talk to your mentor attorney or speak with another person who's doing some, assisting on this, or reach out to a colleague. Date of last arrival, you should absolutely be putting in this information if you can estimate it. You can find this information, for instance, if your client is in removal proceedings, ideally you have a copy of the notice to appear. There is a date on that notice to appear of when they're alleged to have arrived. You can double check that with your client. Does this seem accurate to you? And then use that consistent information throughout. If your client, and this is one of those points in time where I said I would flag certain things that might be different for you, if your client is not, say, a UAC who crossed the border, let's say your client came in on a student visa or a tourist visa, then you need to be including that visa information here, their passport number, their I-94 number, if they use something other than their passport, if they had a travel document, say, you would need to include all of that information here. If they were a UAC and they crossed the border, EWI, entry without inspection, all of that would then be blank. Current immigration status, for most UACs, they have no status. You just say no current status. Some of my colleagues like to put applicant for SIJ or SIJ applicant here. Quite frankly, that doesn't actually mean that's not a status. I mean, it indicates what you're doing on this form, but simply applying for SIJ isn't actually a status, so it doesn't make any functional difference. So you can just say no current status, you could say EWI, or you can say SIJ applicant. This is what the instructions specifically instruct you to do. And then date your current status will expire, NA. If the client, again, entered any other method, then you need to double check what non-immigrant status they're in. So if they entered on a tourist visa, maybe they're still in B2 status. That's something you should check. Maybe they're still in F1, a student, or any other status. So you just want to have a look at all of their prior immigration history and then be putting all of that information here. You want to make sure that that information is consistent. Part 4, processing information, doesn't apply because they're going to process inside the United States. And then moving on, this is the only part of Part 4, Question 2 that you have to complete is literally just the city and the country. The rest of this information you do not need to include. Gender, you should select one. And then, are you filing any other applications or petitions? For most of these clients, again, this was created and targeted towards 99% of our clients, which are UACs from the Northern Triangle countries. They're not going to be filing an I-485 with this application because of the backlog. We're going to talk about that later. However, that may be different for you if your client is not from Honduras, Guatemala, El Salvador, Mexico, or India. So it's possible that you'll say yes, but 99% of our cases right now are no's on this one. Excuse me. Is the beneficiary in removal proceedings? Again, for UACs that cross the border, most of them are, yes, in removal proceedings. This means that you're going to need to complete the additional overflow section at the end, but some of your clients might be what we call affirmative cases. They might not be in removal proceedings. Simply check no and move on. Has the beneficiary ever worked without permission? Does not apply to special immigrant juveniles, so you simply leave it blank. You don't mark yes or no. Is the application for adjustment of status attached to this petition? Again, this is what I was explaining up here on number 4. For some people, they might be eligible to file what we call concurrently the I-485 application, but most of these kids can't do that right now. It has to be 2 separate steps, and there's a big wait time in between them. So for the moment, for most of our clients, this answer is no. And then the rest of this typically does not apply. If your client has a child or is married, has a spouse, you should be talking to either a colleague or your mentor attorney about that situation. Children, more common. Spouse, you might have issues. So in any event, moving on. So there's a big part of this form, because the I-360 is a catch-all for all special immigrant categories, there's a bunch of this information and sections that do not apply to your client. So for instance, Amerasian doesn't apply to you, leave it blank. Filing as a widow or a widower doesn't apply to you, leave it blank. So you're jumping ahead now to Part 8, complete only a filing for a special immigrant juvenile. This is your section. This is the meat of explaining what was done in family court to USCIS, and this is really the biggest change from the old form to the new form, is this part right here. So if they've ever used any other names, you write them here. I like to tell pro bonos and the attorneys that we work with and the attorneys that I supervise, you know, if the kid has ever used any other name in family court, or if they prefer to go by another name at school, for instance, if they have 2 last names but they only use one, or if, you know, in some instances they were abandoned or abused by a parent and they don't want to use that last name anymore. So then provide the alternative names that they've ever used here. That way, once you have all your paperwork and it's all lined up, that they're all iterations of their names that they've ever used that might be on any of their paperwork that you're filing or submitting, that it's all provided here. Have you ever been declared a dependent, declared dependent on a juvenile court in the United States? Answer, yes. This is what you just did in family court. Congratulations, by the way. You came through all of it and got your family court orders. This is our practice at Safe Passage Project. Now this question 2B, is a big one for people. How do you answer this? Because they're talking about provide the name of the state agency, department, or court-appointed organization or individual with which you are placed below. Now, that sounds like who are you placed with? It doesn't exactly fit our typical guardian situation. So the way that we've created our response to this, was to say that New York State Family Court, meaning this is the agency, this is the the court that's making this decision, New York State Family Court for blank counties, Suffolk County, Kings County, Queens County, has appointed a guardian for me. And then usually I write see attached or see order. And then they can look at it, because that's about as close to explaining to them, this is the state agency making this decision, this is the appointment that was made, have a look at the paperwork. Because there's not exactly a one-to-one here with the language that they're using. Are you currently under the jurisdiction of the juvenile court that made your placement or custody determination? Answer, yes. You're still under the jurisdiction, and that's the question in question C, is are you under the jurisdiction of that court? Yes, you still are. If you think the answer to that might be no, you should talk to your mentor attorney. And you might not be wrong, but you should discuss it before filing. If you answered yes, are you currently residing in your court-ordered placement? So, what if you didn't live with your guardian, but the judge still appointed that guardian to you? Are you still residing in your court-ordered placement? The judge knew where you lived. It was disclosed on your guardianship petition. The judge knew where the guardian lived. It was disclosed on the guardianship petition. In our view, the answer to this is still yes. It was all disclosed. You are still residing according to the living arrangement that was ordered by the judge that he certified and signed off on. So the answer to this question is yes. You haven't altered that placement at all. Yes?
No, it's okay,
Okay. So we would, ideally, you're skipping over B. And then part 4, this is the reunification section, talking about the parents and what was decided. So, for instance, a juvenile court has determined that reunification with one or both of my parents is not viable due to abuse, neglect, abandonment, or a similar basis. And then they want you to write in the name of the other parent if there's only one parent. This is one of those situations where the form will only let you check one box, but frequently we get court orders or SIJ orders, we allege everything. I ask my fellows, I expect them to have factual findings made under each and every one of the categories that they could possibly get. And sometimes we actually have one case right now where we're alleging all 4 of these things because the relationship with the parent was absolutely atrocious and then that parent died. So now we have a similar basis as well. So in that case, we allege every single factual basis that we can, so we check off every single applicable factual basis because there might be more than one. For deceased parents, or if you have a similar basis under state law and it's case law as opposed to statute, or any similar law here, we're actually writing out the case names. Matter of Luis, the whole citation. I realize here in the example it doesn't say the citation, but we write the entire citation and say deceased parent, see matter of Luis, and all of it, so that it's incredibly clear exactly what New York state law we are relying on and what that similar basis is. We're trying to make it really obvious for them. All right, number 5, has it been determined in a judicial or administrative proceeding that it would not be in your best interest to be returned to your country? I realize I'm summarizing there. Yes, this is the 5th finding that you're getting in family court. So ideally the answer to this is yes. Question 6. Now this is a big question just to bring to your attention, especially for UACs that crossed the border and were picked up by CBP right after they crossed the border, and maybe they were held in ORR detention until they could be reunited with one of their parents. The Office of Refugee Resettlement is a subsidiary of the U.S. Department of Health and Human Services. So if your client was held in ORR custody and then transferred and released to their parent and then subsequently put into removal proceedings, they have been held in HHS custody before. So your answer to this question, if your client is fitting like ours, is probably yes. If you answered yes, and you are in HHS custody, did the juvenile court order determine or alter your custody placement? Your clients are no longer in HHS custody because they've been released to a parent or sponsor, so the answer to this question is no. Does that make sense? Okay. And not only that, but frequently the sponsors that your clients are released to are also the people that ultimately become the guardians and or custodians that are getting these court orders anyway. And so no, you're not altering any kind of placement. Yes?
Do you mind if I ask a quick question?
Are you ready?
I could take a question right now because this is the bulk of the substance on this form itself.
I just had two quick questions about this page. So for that question that you just did, for 6B, it says, and you are in HHS custody. So none of our kids are currently in HHS custody.
Right.
So why wouldn't the answer to that question be NA? Because that question, like, the language of that question doesn't really apply because none of our clients are actually currently in, I mean, at least in my situation, I don't have clients that are in.
Sure. I see what you're saying. I mean, you could write NA next to it, or you could include an overflow answer onto page 19 if you would like. We've simply just been answered, because you're answering yes, you do need to respond somehow to question B. And so we've just been marking no. Because either no, they're not in HHS custody, or no, it wasn't altering the custody status or placement whatsoever.
Okay. And then in number 3A.
3A, up here.
I guess I don't know. I feel like a lot of people are answering this one differently, but I'm just
Sure.
wondering if, because of the RFEs about custody, because technically the guardianship order doesn't make any placement finding.
Sure, but custody, also, this question doesn't ask about custody. This question asks about court-ordered placement, and we're definitely going to get to that issue in the RFEs because there's a whole section on adjudication issues and how to respond to those.
Does the guardianship order, is there a court-ordered placement? I guess
So I just think this is an inartfully and a terribly worded question. I think saying your court-ordered placement envisions a very extremely limited view of potential underlying family court decisions and orders. And so, but I don't see the question here is asking, are you currently residing in your court-ordered placement? And let's just look at the previous question as well. Are you currently under the jurisdiction of the juvenile court that made your placement or custody determination? And so, and yes, you're under the jurisdiction of that court. That jurisdiction is ongoing. And so the next question then is, if you answered yes, I'm under this jurisdiction of this court, are you currently residing in your court-ordered placement? Meaning, have you altered that decision that was made by that court is how we read that question. And so our answer is yes, we are currently residing according to the court order. But,
Just interrupting for.
sorry, Lenny, is that?
No.
Okay.
It's very good. And the code word for right now is RFE. And I think what you're asking is a sophisticated question that's anticipating something she'll discuss later. So
Yeah.
the code section for this moment in the program is RFE, and I'm going to let you keep going.
Okay, thank you.
All right.
Yes, Maureen.
Oh, no, I was just wondering, because I think the question maybe is also premised on the fact that there are some people who answer, and I don't do this personally, but
Sure.
there are some people who answer no, that they're not under the jurisdiction, and then they answer that they're in permanent guardianship, because they read guardianship as being not permanent guardianship like 661, FCA 661B, but rather guardianship, just a permanent guardianship.
Right.
And these people, who I'm not naming, have never been RFE'd, and so for their post-18 cases.
Oh, I see what you're
So
saying.
there's been some discussion within the Stitch community in New York whether that's actually an interesting alternative. It's not what I do, and I actually thought it was very odd.
We had this
But I really respect the people who do that. So
Absolutely.
I'm very
We've had this debate and discussion on our own staff as far as whether or not you do, like the destination, the checkoff here should be that you're saying, yes, we're in a permanent guardianship versus answering just yes, yes, that you're living according to your court-ordered placement. It's specifically because of this issue of language. I think the problem here really is that we're dealing with a national designed form we're shoehorning into a state court practice, and the language is not one-to-one, and that in New York, in fact, permanent guardianship means something very significant, and that our clients are not in permanent guardianships. And so I would not have that be my destination if I have a classic 661A guardianship placement situation. Yes?
Maureen, I'm going to dispel your myth. I do answer 3A no, and then 3B first check, and I have many RFPs, many NYLS.
Oh.
I wish I had none of them, but I've had a lot. So that's not true. So we should
There's no silver bullet because they don't know what they're doing. So I'm going to put a pause right now on these questions so we can just get through the form itself, and then I promise you we're going to go through all of these adjudication issues. So if you don't mind just holding on for like 5 minutes, because the rest of this is pretty straightforward, because most of it does not apply to you, which is great. We're not religious workers. We're not VAWA. So, all right, so where does your client sign? I get this question constantly. Your client, again, the subject child from the family court proceeding, is now the petitioner on this form. They sign on Part 11 as the petitioner. They do not sign, so this is the statement, either they speak English or they do not. For example, they may speak Spanish. At the request, then the attorney's name goes under the preparer of the form. Put a phone number here for them. If they have an email and you want to include it, you can. You don't need to include a cell phone, you don't need to include an additional cell phone number. And then they're signing here, page 15, item 6. That's where your client signs. They do not sign, and you do not complete Part 12. Part 12 applies to religious workers and some other select categories. It does not apply to SIDG. So you leave it blank. Leave it all blank. If you're using an interpreter, this is where their information goes. They do need to sign this form. And this is you, preparer. This is where all of your information goes. And typically, I am the attorney. Oh, I'm just pointing, not clicking. You are the attorney, and it typically does extend beyond just the preparation of this petition. And then here, so this is, as Meryl was saying, if you don't complete the first page, which as a practice, I do not, my team does not, we haven't had any issues with that, but I am aware that there is that lockbox email that you can reach out if you do have issues. We just handwrite in the family name, the A number, and then, for instance, if your client is in removal proceedings, you need to explain it. And so this is where we just simply say, I am in EOIR removal proceedings at 26 Fed Plaza, New York, New York. I think this address was a little off. 10278. Too many zeros there. Next hearing date, you can include that. That might be more information they want. Or, for instance, my proceedings are administratively closed if you don't have a next hearing date. You only need to explain it. You don't have to provide additional documentation. And that's it for the form. This is what we typically include in our I-360 packets. It's pretty straightforward. It's very basic. A simple cover letter, your G28 form where you're entering your appearance as the attorney, the I-360 form we just went through, and then the following exhibits. You need the birth certificate with a certified English translation. You need the underlying family court order, whether that's guardianship, custody, a termination of parental rights, emancipation, what have you. And then you need your SIDG order. And then if you have a case where a parent, the death of a parent constituted a similar basis, you do need to include that death certificate along with a certified English translation with your initial filing.
And by certified, you don't mean a professional interpreter, do you?
No, but you do need a translation certificate that someone who is fluent in both the native language, the language of the form or the certificate, and English can attest and swear and affirm that they are fluent in both languages and that the translation is true and accurate to the best of their abilities. So that's your basic packet. It's very simple. Now, the I-485 question, can you file your adjustment of status at the same time as your I-360 petition? And the question is pretty simple. You have to double check the visa bulletin. And if the EB4 category for your child's country has anything other than current listed, you probably cannot concurrently file. Almost certainly cannot. For instance, right now, if your child is from El Salvador, Honduras, Guatemala, India, or Mexico, there is no concurrent filing because the priority date is set all the way back at August 15th of 2015. If your child is, however, from any other country, like Chile, or Ecuador, or Jamaica, or Haiti, or anywhere in Europe, or a lot of other countries, you can do a concurrent filing. We are not going to get into adjustment of status tonight because that is a whole other CLE. But this is just something for you to be aware of because ultimately you are going to need to file the 485. That is your actual application for permanent residency. That is the final step of this whole process. And so if you can do it together, that's great. Benefits of doing it together. The client then has a right to remain in the United States while that adjudication is going on, and they're eligible for work authorization. So there are some benefits. You should take a look at it, but we're not going to get into it tonight. This is just an example of what the visa bulletin looks like. So the employment-based fourth category, this is just...
Where does that date, how does this child get the date?
I'm about to tell you.
Okay. You know how I am about this.
I do.
I get very excited about this.
Yeah, so for this date, and this are, again, 90% of our clients are these kids in this box right here. September 15th of 2015, I believe this is the August 2017 visa bulletin right now. This date corresponds to the date of filing of your I-360. The date that USCIS receives your petition at the service center becomes your what's known as your priority date. That locks in their place in line, that locks in any age out issues, and it also tells you at what point they can file their 485. So according to this calendar right now, only people who had filed their 360s prior to September 15th of 2015 can actually claim that visa now and apply for permanent residency. Everyone else has to wait.
So if you went to family court and you're so excited and you're celebrating, you come back to your office
Mm-hmm.
and then you put that I-360, I'll call you in a couple weeks and we'll get that done.
Yeah.
What are you doing to that child?
You're potentially delaying their ability to apply for permanent residency by years. Because at this point, the visa backlog, there are only, what, 700 and...
Approximately 7.
About 700 visas per country per year that can be handed out in this category. And I know Safe Passage Project alone last April filed over 100 of these applications, and that was we're one organization in one city in a very big country. So we're looking at a backlog. We still don't have an estimate yet of how long that line is going to be. So you've got a really long line, and every year the government hands out a few 700 per country of these visas and slowly works its way through that line. We don't know how long it's going to take them to get through it. And it could take them years just to move up months or move up, weeks. We don't really know yet. We'll have a better idea in October when the visa numbers turn over again. And we'll have a better idea again next October because they'll turn over again and we'll start eating through more of that backlog. But until then, it's only estimations.
Last year, USCIS approved 15,000 of these applications, the I-360, for special immigrant juveniles. Now, not everyone is from El Salvador, Guatemala, or Honduras, but the majority are. So again, I just want to phrase it this way. When you're heading off to family court and you're pretty confident that's the day you're going to get your special findings order, I think you should have ready in your folder, along with Megan Stewart's handy-dandy guide to family court and all your CPLR, you have your drafted I-360 ready to go, not pre-signed, because you need to be able to certify it after the order. And I think, because I am very old and practiced immigration law and other times when visa retrogression occurred, a 1 week difference can mean a year. So please don't delay on preparing your I-360.
Especially,
At least everybody in this room is going to be ahead of everyone who wasn't.
and especially when the packet ultimately, as far as immigration filings go, for filing an initial 360 petition, now it can get complicated and we're about to get into it, but that initial filing is fairly straightforward once you have those family court orders. So, and there's a lot of that you can prepare almost entirely in advance. So the filing with USCIS, there's no filing fee required. The packet has to be received by the Chicago lockbox before the child's 21st birthday. So if you gotta overnight it, you gotta overnight it. One note, I know that previously, because of a very good working relationship with 26 Federal Plaza and the adjustment unit there, the supervisors, if we had contacted them and we said, we have a child who's aging out tomorrow, we're getting the family court orders this morning, we want to run this over to 26 Federal Plaza and get it stamped to lock in that priority date, to lock in that age out date before the 21st birthday, which was going to be the next day, they would literally hold the door open for us and let us stamp it at 26 Federal Plaza. Now, that was under the previous administration. That was under the previous field director. So we don't know if this is still going to be.
Did one last week.
And that's great. That's great. But as this administration continues through the years, we don't know how long this practice is going to be. So always check, again, with your mentor attorney or colleagues that are in practice in this area to confirm this ahead of time. The last thing you want is to be there at family court and then say, oh no, I forgot to check about this, and then be calling everyone in an emergency. You know, if we know days in advance, then we can plan ahead, and that's just better. I recommend sending everything either certified with tracking or some sort of delivery confirmation so that if there's ever a question of the actual arrival date and that becomes an issue, especially if you're close to an age out but you're filing, you know, in advance of it, you know, you're not going to get your receipts for 30 or 60 days, so you need to have some sort of confirmation for your records that it actually got there. Yes, Anila.
With regard to the one in the 21st birthday, we've had a little bit of back and forth that may not necessarily apply to custody, since at 18 they're no longer dependent on the family court, so it's better your child is stitched before the 18th birthday and you don't have up to 21.
Sure.
What is your, what's
Well, you still want to be able to say at the time of filing of the 360, and you're right, we probably should amend this and say, according to, you know, the expiration of the family court order. So if it's guardianship and the guardianship goes up until 21, always double check. You want to make sure that you're filing it while your child is still under the jurisdiction of that family court order. So that if it is custody, you probably need to almost certainly get it in before the custody order expires, because then you're no longer under the jurisdiction, and then you can't actually check off that section that says that you are.
I mean, I'd be willing to litigate that one, but we have this other issue, right, which is priority dates, so why are
Yes.
we waiting?
Yeah.
No, I just meant like, if it's about to turn 18.
Right. There have been some cases, and I think everyone knows, that in some states where the jurisdiction even only goes to 18, courts have extended the jurisdiction and dependency of the family court in a matter that was filed before the age of 18. But if you're in a jurisdiction where it only goes to 18 and you try to file after the age of 18, that's going to be some clever arguments. I think Massachusetts had one really good case. Anyway, let's try to avoid it.
Yeah.
If we can, and if we can't, then let's all put our big brains together. Sorry,
Certainly.
I think there was one more question we were going to throw.
Yeah.
So let's say that the birthday's tomorrow, the hearing's today. I've often thought the best thing to do is send the 360 in and see the order will be sent in. Because they'll always do I think they'll do an RFP for the order.
Sure, but you want to make sure that you have, I mean, you can absolutely do that, but you have to be eligible at the time that you're signing your 360. And if you're signing your 360 before you have orders, are you actually eligible? Or before the orders are even issued? So I would,
Some people have done that and actually, unfortunately, have rejected.
yeah,
Okay.
I would be very reticent to do that. And I would, in fact, and I would say if you're getting that close, that's when you want to go to 26 Federal Plaza and just get it stamped.
Well, but does that relationship exist now? Or-
Yeah.
It does, okay, that's good to know.
I'm not saying that it's evaporated. What I'm saying is that it could change. And so advance notice of exactly those sorts of issues is always better.
Contact you guys if we have that issue, right?
Yeah.
Okay.
I mean, we've done a situation where we were getting family court orders in Nassau County. They got the orders. They literally scanned everything into us. And then he took pictures and scanned it with his phone. I printed them at our office, which is 2 blocks from 26 Federal Plaza, and then literally just ran it over and got the copy stamped. And then they filed everything else normally with the additional stamps to USCIS. And so the original signatures were ultimately sent, but we had that stamped certified copy so that the age out was locked in. No fingerprints, no biometrics as part of your I-360 petition. And the statutory adjudication period for this petition is 180 days. This is according to the TVPRA. I know in our office, are seeing significant delays in the adjudication of 360s, and we are considering some mandamus actions. Stand by for more on that front is what I would say. But there is a statutory, it is written into the TVPRA that they are required to adjudicate it within 180 days. Another argument that we are looking at, the I-360 approval constitutes a parole in the US. And so this has come up in a couple of issues given the recent ICE enforcement actions that we're currently addressing. So I just wanted to note this for the room. And this is according to the INA 245, H. All right, and you thought you were done. Everything was filed, everything was submitted, you'd come through fire of family court and done so good and got your orders and filed everything on time, and then USCIS said, nope, we want more. You're not done yet. So there are three main ways that this comes up. The biggest one is requests for evidence. So while your petition is with USCIS and they're looking at that evidence that you've provided, they might say, I'm not buying it. I want more. Tell me more about this or that. And so they will send you a notice, and this is pre-approval, and they'll allege whatever is missing. And they'll say, send us this. It's your burden to prove this case, and you haven't proved it yet. And they usually give you 87 days to respond. Sometimes you get notices of intent to deny. These are issues of law and evidence. This is, again, during the pendency of the 360 petition, but they say very clearly, if you do not respond to this, this automatically converts to a denial. And so you have to respond, and typically you're only given 30 days to respond to a notice of intent to deny. Now, you can request additional time. Say, for instance, I had a client, they were asking for original documents from China. We had to write to China to get them. It was going to take more than 30 days to get that. So they gave us more time, but we had to justify it. And then the last one, which is my favorite, that we've only just now really started to see, is notices of intent to revoke. So this is a client or a situation where you have an approved I-360. USCIS said, yes, approved. We consent to the designation. However, your client is stuck in the backlog, and so you haven't yet filed the 485, you haven't yet claimed that visa, and then USCIS has taken a second look and said, actually, about that approval, we were wrong, or some new facts have come to light, so we're going to need that back, and you're usually only given 30 days to respond to this. Again, you can request for more time, but you have to justify it. General tips for responding. This is the heavy lifting as far as legal practice with USCIS. It should be a legal memorandum. They're reviewing the evidence according to the legal standards they're supposed to do it, and they're making certain determinations as far as deficiencies, etc. So you should be responding in kind and take it very seriously. This doesn't necessarily mean it's a 20-page legal memorandum, but it should be thorough. Key points to look at. Are they actually making an accurate characterization of the record? Are they looking at the complete record? Are they actually looking at the language of the record that's being used? Sometimes they're just wrong. Sometimes they ask for things that they have, and they just aren't looking at it. You know, they're not perfect. They're also frequently not lawyers. So make sure that what they're asking for is you haven't already given to them. Also, the legal authority they're looking at, are they citing it correctly? Are they using an accurate citation of either the statute, the reg, or even the policy manual? Or are they selectively citing to what they want to see, which is a lot of what we're seeing now? And are they even citing to the correct legal authority? And keep in mind and never forget the hierarchy of legal authority here. The statute trumps everything. So if they're citing to the policy manual and saying, you need to give us a custody order, well, I'm sorry, but we're supposed to demonstrate dependency, not necessarily custody. And so that's not what the statute requires. And if the statute and the policy manual, with all due respect, disagree, the statute wins. So keep in mind the hierarchy of legal authority here: statute, regulations, and then the policy manual, which, quite frankly, I think it's hilarious that they cited us anyway, because that's an internal document that if I were ever to cite it at them, they would literally laugh at me. So, yeah.
The form legal memorandum, is this like other immigration practice where it can be in the form of a formal letter?
Yes, exactly.
It doesn't have to be like litigation practice?
No. This isn't like a brief, but it should be a thorough memorandum that's walking through both the evidence and the legal standards. Yeah. I wouldn't simply send in evidence with just a simple exhibit list and say, here you go. You really want to make sure that you are also doing a thorough analysis and that you've reviewed their analysis and that A, what they're asking for is even correct, and B, this is how you would respond to it.
Before we take questions, just want to make sure you in this field, the regs at 8 CFR 204.11 are out of date, and so if something's contradictory in the published reg, because the statute was amended, there were proposed regs issued in 2011, Maureen, and they're still pending. So you have to just be careful when you are using regs, and in our special immigrant juvenile manual, I wish I could have handed out to everyone today, except it's 85 pages long, so it's going to be...
And we're still finalizing the hyperlinks.
We expect it to be posted to the Safe Passage Project website. If you were a pro bono lawyer with us already, you already got an advance copy, but we are cross-referencing and making it hyperlinked. It explains a lot of those kinds of things. So that will be available to everyone on the Safe Passage Project website. I just had felt compelled because I teach administrative law.
Yep.
Anyway, good job. Keep going. We're going to run out of time.
I know. So I have a couple of examples of very common RFEs that our office has been seeing recently. So I'm going to run through these, and then if you guys have any other questions, you can either see the three of us up here, because I know we're all responding to these. All right, so the first one, and this one is definitely my favorite. We are requesting a copy of a juvenile court order that establishes that the court's conclusions of law derive from relevant state laws, or you can also give us any supporting documents contained in the court record, right? So this is part of the big long letter that they're giving you. So what they're taking issue with here, it seems, is that on the New York court form, there is a citation that's included to 8 U.S.C. 1101A27J, which is the definition of SIJ. This is the outline of the SIJ statute of the special findings that the family court is being asked to provide. So how are you responding to this? What I would say is that while you're in family court, and this is that planning ahead, thinking ahead, whatnot, review the language of the GF42 that's provided online, that's provided to you in a sample, and make sure that you are incorporating at both the very beginning introductory section when you're talking about the jurisdiction and authority of the court, that you're folding into that the Family Court Act, whether that Family Court Act, the Surrogate Courts Procedure Act, whatever your authority is for the underlying proceeding. For point 3, right, where you're talking about dependency on the family court, you want to make sure that you are outlining what that dependency is based on. Is it guardianship? Include the citation for guardianship. Is it custody? Include the citation for custody. Whatever the statutory authority is for the underlying dependency action, you want to make sure that that statute is cited right there in the SIJ order. And then for point 4, I have been, at least in my practice, with my team and with my pro bonos, in point 4, when you're saying reunification with mom or with dad, is not viable due to abuse, neglect, or abandonment, that you are including the New York State definition site of any of those terms that you're using. And I just put in the section of law right there. And then the factual findings immediately thereafter. And you want to make it just abundantly clear exactly what the state authority is that you're relying on and that the judge is relying on. And then we even go so far as to include, again, matter of Luis, if you have a parent that's passed away and it's similar basis under law, including that citation in your SIDG order, where you're saying this is based on a similar basis under law, this is the section of law that says that the death of a parent is sufficient. Yeah, sorry. Yes?
So when you're saying all this stuff should be in what, your draft order that you hand up to the family court judge?
Exactly. Yep. And, have someone take a look at it. Have one of your colleagues have a look. Because this is where the judge was saying, this stuff is changing every day. This is exactly what he's talking about. As far as, yes, Maureen.
Sorry, I'm sorry.
No, go ahead.
So, can I just make 2 suggestions? It's not, one is that many of us are trying to take out, I know you are as well, the 8 USC citation altogether, and I think to the extent that we can, it's really important to do so, actually. And we're all getting a lot of pushback from judges, but we're working on that. And the other is that there's a lot of judges who won't allow citations to statute, but will allow, as Stephanie was just saying, to case law, and so it's sometimes helpful to have 2 orders, one that actually has a citation to like the Family Court Act, and another one that has a citation to matter of Trudy, whatever,
Right.
Second Department, because there are some judges who are a little bit odd about that.
Sure. Or this is also a good practice tip as well, communicating with the court attorney. The judges don't make these decisions in a bubble. They have support staff. They have people that are pre-reviewing everything, including the sufficiency of the fingerprints and all the other forms and everything else you're doing in family court, and checking off their list and handing it off to the judge. The judge can make a final decision. Communicate with that person. They know their judge better than you ever will, and so they're going to know he's never gonna accept statutes. You just have to cite to matter of Trudy. They're gonna tell you that. So make sure you get that person's name, you get their number, their email address, you communicate with them, and that way when you're walking into court that day, you know that you are going to have something, A, that they will sign, and you've communicated with your colleagues and you know, okay, this is the best practice at this moment. However, the reality is, we filed 100 applications last year and the form was different and we weren't getting these RFEs yet. And you can't necessarily go back and change it because some of your kids have aged out by this point. So what do? They accept, and this has been a very interesting creative solution, attorney affirmations that are outlining, so in lieu of providing all of the underlying paperwork that you sent into family court, because you may or may not, as a practice pointer, want to do that. There's certain information, certain confidential information specifically about the guardian or household members that you don't want shared with USCIS. In lieu of doing that, you can create an attorney affirmation that says, I was the attorney of record below, or I have reviewed the entire record below, and this is what was done in family court. This is what it was based on. And essentially lay out, this was the legal basis, this was the factual basis, these are the documents that were reviewed by the judge, these are the people that testified, and these are the findings that were made. And those have been sufficient. You can also think of some other creative ways to respond, but I would just flag, these RFEs get really specific. And they are phrased in a very specific way, which is why we're not getting too deep into it right now, because you need to respond to precisely whatever your specific RFE says. Another really common issue, and this was something that we were talking about earlier, evidence that the court order that you submitted was issued by a juvenile court with jurisdiction over your care or custody as a juvenile. So this is a question about the authority of the family court jurisdiction, or the authority of the family court and jurisdiction of the family court. So this is where we're talking about the New York Family Court Act, the Surrogate Court Procedures Act, that gives the basis for jurisdiction over the subject child and the scope of that authority. But beware of this term, custody. We are seeing it everywhere, in RFEs, in NOIDs, in revocations. in our opinion, it's overused. It's potentially ultra-vires the statute because frequently they are citing to select sections of the policy manual that is a very limited view of dependency, and that custody is not the only underlying basis for SIDG here. And so why on earth are you only asking for this? And so we have some very interesting and aggressive responses to some of these RFEs that are exciting to read. And I know that as part of the iCare Coalition, is this the work that you're doing in coalescing a lot of these RFE responses?
Oh, yeah, I'm not part of iCare, but yeah, so
Oh.
if anyone has RFE samples that they want,
Yeah.
the angrier the better.
Yeah.
Yeah.
Yes, right. So I know that the SIDG practitioners, we are bringing together a lot of these RFE samples. So if you get an RFE, please redact it, redact your orders, and share it with us, because we're creating some master lists and some really extraordinary responses to these RFEs so that we can all sort of work together.
Where should these be sent to?
Well, Megan,
Well,
Is-
Megan was collecting the responses, not the RFPs themselves.
I know
Sent the
that
RFPs themselves.
I know that Teo Liebman is also collecting specifically the RFEs in the underlying orders, so that if you have one, he wants the redacted notice as well as the redacted court orders, so that we can look at those things together, so that, and sort of mining it for systematic issues. Yes.
Those of us that are not part of, because we are private practitioners, we are not part of the SIDG to live serve.
Sure.
How can we just get the information? Because regarding the RFA, is really a lot of issues that bring up and rise a lot of stress for the private practitioner as well.
Yeah.
Particularly for those that we filed last year, long before the actual administration. And the kids are aging out, and we need the.
Sure. And with the kids stuck in the backlog, they're taking second and third looks at all of this information. So,
We can go back to some of the court now, because family court will not have jurisdiction also, so when they are rising issues as custody, dependency, all these kinds of things that are just.
sure. So as far as where private practitioners can go, I mean, it's a hard answer. It's not a perfect answer. I know that the SIDG providers, we're doing our best to pull a lot of information together. Also, I mean, I would say at the very least, you can always reach out to us. I mean, I know that I've been willing to speak with my pro bonos even about their private cases when they have RFEs like this. But my best advice would just be to be an aggressive lawyer. You know, look at, if they're citing the policy manual at you, read the policy complete section that they're citing at you and see how they're actually citing it. Are they being selective? Are they citing the whole thing?
Just going to supplement your answer to that. Rebecca, who's on the ALA Pro Bono Committee, was at the SIDG Providers meeting, and we did have a conversation that we would eventually share our robust responses as well with ALA. Because what we're trying to do is, all of us, they have standard RFPs, they have standard noise, we're going to have some robust responses.
Right. One last,
You have a few more minutes, so I
Yeah.
think we can just hang out a few more minutes.
that's fine. I just have two other tips, but really this one I think is super important. If you have a client who has any immigration history, you need to have that immigration history in front of you at the time that you're completing the I-360. This means that if your client came in on a visa, let's say as a student or on a B2 visa, or had filed any previous applications ever, if you don't have it, if your client doesn't have it anymore, you need to file a FOIA and you have to get it. Because what they are doing now is and they've been doing this all along, but especially now, are cross-referencing all prior applications for fraud. And that if there's any discrepancy between what your client said 1 year ago, 2 years ago, 3 years ago, on a different application in a different context, and what they're now saying on their I-360 or to the family court, USCIS is going to take a lot of issue with that and say either that you lied to the family court, you misled them, because this is the information that we have, or they're going to second guess whether or not your intent in filing your I-360. And so, for example, a client who came to the US on a student visa, There are statements made on the record in their DS-160 when that they filed with the State Department, as well as at the interview that was at the State Department, that can be used against them in any subsequent filing. You have to file a FOIA and get a copy of that DS-160. The same issue for, and we're also starting to see this for children who cross the border. Statements made in custody on that 213 form. Statements made in a credible fear interview. Why are you coming to the United States? I mean, we've seen responses written on this for children as young as 3 months. They're not even totally verbal yet, and the government's saying, oh yeah, they said they came here for work. Of course they did. But those statements are made on a government record that then can be used and crossed when you're filing your 360. So if your client has immigration history, you have to have it. Pre-filing, the minute you take that client, you have to file a FOIA. Even if that FOIA doesn't, before you even go into family court, you should be doing this. And even if you don't get it back until, months later, prior to filing the 360, even necessarily let's say you have an age out case and you can't wait, even if you don't get it back until after filing the 360, you still ultimately are gonna need that information because that's what the government is looking at in doing their adjudication. And I would say you should have it in hand at the time you're completing that 360 form. If you need to request additional time, you can always do that, but you can reconcile whatever conflicts or conflicting statements were made through additional affidavits, other contemporary evidence, that sort of thing. But there's no substitute for immigration history.
And more importantly, if those issues come up, and they do come up, we need to state that misrepresentation shall not apply.
Right.
And they forget that.
Well, but again, this is an issue at the 360 stage, not the 485 stage, which is an important distinction. Because, as Meryl's pointing out, there are certain bases for inadmissibility that don't apply to our children once they're filing for their green card, but they can be used to undermine the credibility of your client and impugn their intent at the time of the 360 filing, which is the way we've seen it used. So I would say this, we can skip this last one. We could go through example after example of these, but again, we're compiling a master list, so if you're on our pro bono team, we'll hopefully be sharing more of these and sharing best practices as they evolve.
So I want to thank Stephanie.